So the question inevitably would be asked is, where does WHO as an international organization stand as far as fulfilling its legal obligations? Now, a little later, I would go into some of the legal obligations, but I would just like to highlight there are these two major texts that you have with regard to the legal obligations as far as the WHO and the health issues or international health issues are concerned. And those are the WHO Constitution, and then you have the International Health Regulations under the auspices of the WHO 2005. Mind you, both these are not soft law instruments. They are actually international treaties and convention status. And that's where the whole idea of grounding the importance of China being taken to the processes of law. Now, which processes, what processes, how it is going to be, those are all questions that can come later. But first we need to understand where at all there is anything called international health law. Now, way back in 2012, this was the first time we actually heard about something called an international health law in this country. We never even understood that there could be something called international health law at all, because we thought that all health is domestic law. So the best that international law could do is try to make these guarantees for individuals that they have a right to health, they have a this one. Now, when did that happen? Way back in 1978. So there was one declaration called the Almata Declaration, wherein they understood that there could be something like, an international right to health. So that later on got transported into the idea of the WHO guaranteeing some processes and the international health regulations laying down the protocols. Now, the contestation here is that there are no substantive rights in those two conventions. It is all procedural. Now, that's again a matter of contestation. So at this stage, I would just like to run you through a small presentation trying to tell you where are all the legal issues being sourced in, or at least I'll try to give you a snapshot of the legal issues, and then later on possibly we can understand how these issues are spread out. Now, I'll be trying to take you through both the public law remedies, the public international law remedies, as well as the private cross-border remedies as well, because both these angles are now being tested. So just like to share my screen here. If we can just wait for a minute, I will just pull up that. Okay, I guess can people watch, see my screen here? Is my screen visible? Maybe I just need to expand it a little. Is that making sense now? Or just I'll probably run it on a slideshow. So the graded resolution law begins. So we have previous experience with handling of disputatory nature. It's all restricted through some case law that was developed. Like I said, the Alabama case, the Trail Smelter, the Curfew Channel, and the Pulp Mill case. It all does this idea of transboundary come in? All because the idea of virology and the idea of zoonosis basically means that these viruses that travel through the host move everywhere that the host moves in. So the coronavirus, we have had 3 such pandemics, the SARS, the MERS, and now the COVID-19. And all 3 of them had created a transboundary harm. Right. So that is exactly why we need to now look at virology essentially as explaining the kind of graded response that international law could actually give us. Right. So I would love quickly take you through the law as it developed. But if you look at it, the first response for international law was largely with regard to state responsibility stated out in the curfew channel case. Now, in the curfew channel case, they show that wrongful intentional acts of the state. So the idea was that it has to be an intentional act of the state where that act amounted to a breach of its international obligations. So there was something called a wrongful act, yes, but it was preceded by the word intentional. And that's exactly where the problem comes in, because transboundary harm doesn't care for your intention. Right. So the idea of no harm principle was only largely coming in the later cases. And then that came into international health law at a later stage. So when we talk about the WHO constitution with 194 member countries, including China, it is largely based upon the principle of no harm and the idea of due diligence. So if you look at the WHO constitution, it largely talks about how an international organization is structured. Right. And it talks about how the duties and, the procedural law, basically it's largely the how the institution is constituted, how are the reports to be communicated, and how the internal structure of the WHO is administered, and what is the method of communication. Right. Now, with regard to the substantive matter, there is largely the understanding that all public health epidemics of emergencies of international concern will be reported. Now, what exactly is a public health emergency has been left to the nation states. Now, that's again how the international organizations are largely like a soft power diplomacy. Like, for example, I come from one international organization, and trust me, we know how difficult it is to get countries to talk. Right. So we are talking at places where the countries who are members of that organization often have this. So it is largely the idea of a soft power diplomacy that works in. So when they place things into the structure of the international organization, the idea is largely to get members to talk and members to communicate their responsibilities, and maybe a substantive idea will later stage. But now the most important thing is to ensure that responsibility towards communication is pinned up. And at a very basic level, it is understood that these 194 countries will not interfere with the WHO Director General or his office. Now, mind you, I'm saying these two important words, will not interfere and influence, because these are the two major issues that countries are now complaining of. Right from the US, you would say President Trump and on one end of the globe, and Prime Minister Harrison at the other end of the globe in Australia, both of them complaining the same issue, that the WHO functioning raises questions. Now, that is exactly what the Constitution basically tries to prevent. The Constitution is more or less, through all its articles, tries to emphasize upon the independence and the inviolability of this WHO organization. Now, the next part of the WHO law is importantly that the Health Assembly is said that at regular intervals, you need to prepare these regulatory activity. So till 2005, all these regulations were just left here and there, scattered in declarations. But post the first coronavirus thing, the SARS attack, it was like became pertinent that there has to be protocols, and the nomenclature protocols were specified in the International Health Regulation of 2005. Now, please note that this is also the time when domestic forums and regional forums were increasingly taking notice of right to health. as I will show you later on, other regional organizations also started talking about right to health as part of the right to life under ICCPR, and also a right to health under the International Covenant on Economic, Social, and Cultural Rights. Now, apart from these two instruments, the other major international law that is being discussed is with regard to the general international law. And this is exactly where the whole issue of, the current discussion on whether there can be a complaint against China taken up. Because if you had noticed, the International Commission of Jurists and the All India Bar Association, for us, our own country, has given a complaint to the UNHRC, the UN Human Rights Commission here, asking for, a case against China for an unspecified amount of reparations, only because they think that these articles on state responsibility for wrongful acts, the ILC's articles, the draft articles, never one imagined that there would be a COVID-19 pandemic to actually test how these articles can actually be worked. But that's exactly coming to a lot of use now to understand what exactly is state responsibility for wrongful acts. So I'll just run you through those things. So these are the allegations that are made against China. Where do we find these allegations? Well, they are available in much literature that has been brought out by many of these international law academic and learning institutions. One place where you can source them is the European Journal of International Law, where they have mentioned a couple of allegations that are made. One is that it withheld early reports of the epidemic because that were discussed by their own medical staff. Now, mind you, this becomes a very, very important allegation, because at a later stage, I will show you how the University of Southampton had done a study to show that if only these reports were available much earlier, the impact of this epidemic, this pandemic, would be much reduced. Like, one of the projections was that 66% reduction would have been there. Well, I don't know, but the range is between 34 to 66, right? And the second allegation against China is that it withheld classified governmental information regarding data on asymptomatic cases. Now, this is another word that we all are hearing so much today, asymptomatic. Right? Now, the allegation against China is that it has withheld all this asymptomatic data, because if this data were available, we would have helped determine the contagiousness of the virus much, much before. Right? So, all this doubt that we have with regard to R naught is